ordinarily, again, if you are raising before the Court of Appeal a question as to the validity of an election of a president, then the process should end with a determination either that the election is valid or that the election is invalid. That's the normal end of the process. But of course, in order for that to be the end of the process, you first have to have an election. So we are saying, we respectfully submit, when you interpret those words, the first impression that you get is that you have to be challenging the election of someone. Somebody's election is under challenge. Somebody's election is being said to be invalid. And therefore, you will be interested to identify whose election. Because if you are making the application saying that somebody's election is affected, you first of all have to ensure that that person is before the court in order to invalidate that person's election. It is interesting, of course, that Ms. David commenced these proceedings and did not name any presidential candidate at all.
The Court of Appeal had jurisdiction, but even if I am wrong, I see that this court lacks the jurisdiction to entertain this appeal because the clear and necessary intent of the Constitution and the agreement is that disputes of this type end in the Court of Appeal, even if the Court of Appeal was wrong on the question of jurisdiction.
Mr. Jeremie, so do I understand that, and this is hypothetical, but I need an answer to get an idea of your thinking. Let's say that the Court of Appeal had said that we interpret this phrase in the sense that only if the candidate gets more invalid votes than the other, which would, of course, be quite absurd. But suppose they had said that. So then it is your opinion that, well, it may be absurd, it may be crazy, but that's what they said, so it's final. I just need to know where, if there are some limits, at least in your thinking, or not.
My Lord, in respect of the sovereign pronouncement by the Guyanese Parliament in enacting the CCJ Act, and in respect of the provisions of the Constitution, I say with regret that on the authorities, as silly as that proposition is, and of course we are not dealing with that in this case, that's a hypothetical. What the Court of Appeal has said, as your Lordship has quite correctly put it, is that more votes means more valid votes. That's all that they have said. Now, if they had said that more votes means invalid votes, this court has no jurisdiction to trespass on that.